Hello and welcome back to Diddy on Trial from BBC Sounds and the BBC World Service with me, Anushka Matanda Doughty. Make sure you subscribe to the World Service YouTube channel so you never miss a thing. So Sean Diddy Combs has been held in the MDC Brooklyn, the Metropolitan Detention Centre, since September. He's there on charges of sex trafficking, transportation for prostitution and racketeering with conspiracy, all of which he denies. But in the meantime, his lawyers have been building his defence. And we're kind of in the home straight now, so we're starting to see how that's going to be shaping up. Now, we've got to remember this is for the big federal trial that's concerned with his freedom, not the civil cases which are concerned with his money. So Diddy's defence team has issued a letter to the judge stating that, quote, contrary to innumerable sensationalistic media reports, the sex tapes that are currently part of the case do not depict sex parties. There are no secret cameras, no orgies, no other celebrities involved, no underground tunnels, no minors. Joining me today is our resident criminal defence attorney, Sean Kent. Hi, Sean.
Hey, how are you guys doing?
Good. I just want to ask for your followers, everybody who loves you, you still banned on TikTok or are you back?
I would guess we're 80% back, so we're back on TikTok. We're up, but who knows how long it's gonna last. It sounds like we've got at least a 90-day reprieve from the executioner, so we'll see how much longer that lasts. But we're back for now.
The defence, it's shaping up to be exactly what you told us it was going to be, a defence of consent. So it's all about consent. I mean, can you just explain to us a little bit what's gone on with these and what the defence have said?
So what the defense has done is they're taking an interesting tack, and I think the legal analysis is becoming fascinating. And they're saying if you look at these videos, this shows a consensual relationship. If you was The great thing for them, for their defense about that is that's in the past. All the folks on social media and so forth are saying, well, these people are drugged. They're saying they're drugged. Don't forget, it's easy to prove the court of public opinion, but when you get into an actual court, the federal government has approved their case beyond a reasonable doubt. And someone just getting on the stand and saying, I was drugged, the defense can ask a very simple question. Where's the drug test? Where's the proof? You just saying it now, there's a lot that's going to happen. And I understand where the defense is going. There's like, this is consent. And if it is consensual, butt naked baby oil freak off parties aren't illegal. What's illegal is the sex trafficking aspect of this case. And they're saying there is no sex trafficking. Always was going to be the defense, always.
Well, look, we can't say who victim one is as the BBC because the prosecution have not announced who victim one is. The defence have defined them as somebody who had a consensual relationship with Sean Combs, and they are still participating, they're giving evidence to the grand jury. They've said it's consensual. I mean, how do you prove that?
Well, don't forget, here's the great thing about it. Don't We're innocent until proven guilty. It's not how do they prove it, it's how does the government disprove it. So if you're the defense and you're showing the video, they're just like, well, look at the video. The cross-examination is going to be intense. And by that, I mean from the defense. Because, of course, what's going to happen is the prosecution gets to put their witness on first, whoever it may be. And this female who had the relationship with Mr. Combs is going to get on the stand. I guarantee you she's going to be emotional. She is going to cry. She's going to talk about this relationship. She's going to talk about the fact that she was forced to do things she didn't want to do. She is going to say this in a very good way. That's evident. The cross examination is going to be withering. It is going to take this video frame by frame. This is you with a smile on your face. In this video, anywhere whatsoever, do you say no? In this video, you are seen walking in this way. It doesn't appear that you were on drugs at any point in time. The cross examination is going to be withering. And so, everybody who is just reading, it's one thing to read evidence that we have half and half of it, but it's another thing to have a witness on the stand who is going to talk about the fights in the relationship, the fact, the money that she got, the things that she got. When we define cases, when we do cases, Nushka, what we always say is a witness's credibility takes the stand with them. So this person's credibility is going to take the stand. And so the biggest question I think that's going to happen is the following. If Mr. Combs is this most disgusting, abhorrent human being, if he is the monster that you and the government has said that he is, why did you stay with him?
Presumably, then the prosecution must be preparing that person because that is an awful lot to go through.
They would, and I prosecuted it. And what ends up happening is you have to be careful when you are preparing a witness. There's not a lot of evidence. There's videos and so forth, but the evidence is going to come from the stand from the person's mouth. And so when you are preparing a witness to testify, especially as the government, it is the hardest thing to do. Why? Because you're not allowed to what's called lead. You're not allowed to suggest the answer. So really what you're doing is you're trying to get a witness simply to tell their story. So you would say witness one, realistically, you say what happened. And then you say what happened next. That's how we're taught as prosecutors, as a former prosecutor, to get a witness to tell the story. And so what you want to do is you want to balance something. You can prepare this witness too much. Because if she comes across too much, if she comes across rehearsed, if she comes across polished, then she comes across as unbelievable. And if you prepare somebody entirely too much, and I've made this mistake as a young prosecutor, when you want to meet with a witness over and over and over again, and what ends up happening is you meet them with them 5 or 6 times and they keep crying. They keep crying because they're emotional about this event. Well, by the 10th and 11th time, they become desensitized to it and it's not emotional to them and they can't cry anymore. And so, yeah, they're preparing her, but they can't over prepare her because they don't want her to seem too polished. And she's got what we call as warts. Um, she has warts in this case because she has problems that they can't get past. You can only prepare somebody so much for the fact that, ma'am, according to this, you were with this monster. And presumably, you are also a criminal. Because if what the government is alleging is true, if Mr. Combs has engaged in this abhorrent behavior and you were by his side, who did you call? What law enforcement did you contact? What person did you warn? And so she's got two options. Either she didn't see anything, and she didn't see anything, guess what? That goes along with Mr. Combs' defense, or she saw something and didn't do anything, and then that hurts her credibility. That's why I was like, don't be so quick to assume that the prosecution's case is the greatest case in the world because the cross-examine of her is going to be withering.
And we can assume now that we're at a point, am I right in saying that the defense are having a look at the evidence that the prosecution have to start preparing their arguments in depth? And I think I'm right in saying that they don't want these tapes dismissed. They want to be able to have an electric copy.
Exactly.
Why wouldn't they have one anyway?
And that was weird to me. As you're not the only one asking that same question. I'm just like, shouldn't you already have this be a discovery? Shouldn't you already have all of this evidence? So that was something that was wild to me at all also. But a lot of times what we have in the federal system is what's called a protective order, which says we will give this evidence to the lawyers, but don't you dare share it or leave a copy. Specifically, don't leave a copy with the defendant. We don't want him to have a copy while he's incarcerated. And so that might be really what they're saying is we need a tangible copy so we can give Mr. Combs so he can go through it line by line. I'm sorry, frame by frame and go through it in full detail. That's my assumption is that he is not allowed to have a copy because that's usually the protective order a judge rules on these high profile cases or almost all federal cases.
To protect victim one?
Protect any victims, any potential victims. That's usually why they do the protective order, not even to make it that specific. Federal judges are very scared of releasing evidence to protect victims, and that happens a lot of times.
So they've essentially now filed this letter, which is public. I mean, it's been written up countless times, talking about evidence that is then going to be used in the trial. Isn't that going to bias the jury pool, or is it normal to talk about evidence beforehand, like openly?
And if you notice, they filed a letter and immediately the prosecution came back and was like, what the heck are you doing? The only reason they filed that letter was to prejudice the pool so that we doing exactly what we're doing. Everybody on TikTok, social media are talking about those tapes because clearly the court of public opinion is against Diddy. It 100% is. So that filed that letter, I believe, in hopes of the prejudice. But the second they filed it, you saw completely what ended up happening. The prosecution came and filed a secondary letter and said, whoa, there's entirely too much information.
So this protective order that stops the defense having this piece of evidence, when the trial starts and the jury sits, will they be shown these tapes?
100%.
Will they have to watch it in court? Like during the
100% in court in front of a room of people. And so that's the other thing that's awful. They are going to be watching basically porn for hours on end in front of people. So in front of victim one, whoever it may be, there's going to be porno played in the federal courtroom.
And victim one would have been made aware of this.
Oh, 100%. She's probably being told right now, like, this is going to be played in open court. Your sex history, your sex life is going to be talked about in open court. All of this.
And presumably then she knows that and she's pushing forward because she hasn't withdrawn.
But don't forget this. It doesn't matter if she does or she doesn't. This isn't a civil case. This is the criminal case. So she could flat out tell the federal government, I don't want to participate. And they can say, we don't care. This is a crime. Crimes are against the United States, not against, they keep calling her victim one, but don't forget, she's a witness to a crime. So it doesn't matter. She went to them in today and said, I'm not participating. Their response, we don't care. Get your ass on the stand.
Do they prep you for stuff like this in law school? Do they say, you know, you might do a case and you might have to watch hours of pornographic material and comb through it? Like, what's the semester on for this?
Well, you're exactly right. They don't prepare you for that because you understand every case is different. So you read about cases. Like I think this Diddy case is going to be studied forever. You know, I think it's going to be studied in law school, but that's the way that we learn is because of what happens with cases is how you learn things that could happen. Like when I was in law school, we studied the O.J. Simpson case because that was a case that had happened. But anybody before O.J. wouldn't have known about these cases. We wouldn't have known about court TV and things of that nature because it didn't happen.
Now, we know that they're seeing some of the evidence that the prosecution have, the defense team, and this is going to help them build their defense. Does this mean that they've got a sort of in-depth, we're alleging that he did this at this time on this day? They've got that? Because you spoke about this before. It's called an enterprise letter.
Yeah, they haven't had it yet, but what they have is exactly what you want. Usually what ends up happening is the defense could file what's called a bill of particulars. A bill of particulars in the federal system is exactly what it sounds like. It's basically, here's a bill. Or like if you go into a restaurant and you order food and all of a sudden the waiter gives you a bill and it just has a total on it, $75, like, well, what the heck is this for? Break this down for me because you just gave me a bill. Well, the indictment is just the bill against Diddy. Tell me exactly what I ate and exactly what I paid for to get to this $75. The bill in particular says federal government break down the charges, the dates, the time, the people, because you've made this allegation and you haven't broken it down. Well, that's why the government said you don't have to file your bill of particulars, Mr. Combs. We're going to give you an enterprise letter where we break down our times, our dates, our allegations, who we think is involved, the other parties, all of the people here. That being said, we're not going to give it to you until March or whatever the date is. Here's our letter. Ha ha. You got 2 months to prepare.
Is that normal?
Yes.
Can't you accuse them of, you know, messing up your defense because you didn't give us adequate time to prepare?
Yes. But in the grand scheme of things, the judge is going to say, are you guys ready? You're the ones who wanted the speedy trial. Don't forget, this was the defense who was saying, we want this trial ASAP. It's not, the government is not doing anything untoward, if you will, because their argument is, we don't want to give this enterprise letter a day sooner. What he shouldn't be concerned about is possibly the reason the government is waiting so long is there's going to be some people on that list who are in his inner circle who he does not know.
But then so if they get the enterprise letter and there are other people on there who are wrapped up in being part of the criminal enterprise, right? Are they co-defendants?
Great question. Potentially, like we're all waiting for that. And you are not wrong on that because in the history of the world, I've never seen a RICO charge with one person. By definition, you can't have a corrupt organization with one person.
Shout out to Dave Chappelle because he literally said that in his stand-up the other day. And then I was there, like, he was like, Diddy's in so much trouble. He's the only person with a RICO charge against one guy.
Exactly right. There has never been a RICO of one. By definition, you can't have it. RICO says 2 or more. So yes, other names are coming, and it probably, not probably, it 1000% is going to come with that enterprise letter. So they can say, this is who you're dealing with specifically.
So then do those people get wrapped up into the trial? They have to get their own lawyers because they've been named? Yeah?
Yes and no, because here's potentially, and of course, assumption based upon experience, they already know who they are. They've already struck their deals. They're already ready to testify. So they've all already been talked to. They know what's coming. They're not going to be surprised on March 8th. They already know all of this stuff is coming. And probably a lot of them are going to be witnesses. And so that happens also, that these people will get on the stand and they will testify. They'll say, I was there with Combs. He directed me this. He was doing this, this, and this. Now, the cross-examination of them is going to write itself. How much time were you looking at? You were looking at 20 years. The government came to you. They never listed you in this RICO charge. So this entire time behind the scenes, you were working to save your own life. That's why you're testifying to this now. If you thought this was such a bad crime, if you thought this was so crazy, if you thought this was so intense, how many times did you go to law enforcement? Who did you contact? Who did you warn? Who did you help with a lawsuit? The cross-examination is going to write itself for these people if they knew, which I bet my eyeglasses on, that they knew that these charges were coming, and they've done nothing about it. So they all have lawyers already.
Now, look, he's been charged with sex trafficking, transportation for prostitution, and racketeering with conspiracy. Sean Diddy Combs denies it all. Okay, so that's the latest on the Diddy situation. Now it's time for a new segment. Now, I've seen what you say in Sean's TikTok comments. We're late to class, we're early to class. He's our law professor, and I agree. So we're going to do a section called Class is in Session with Sean Kent, because I don't think Diddy's defense are going to slow down so we can catch up with what's going on. And the US judicial process is pretty mystifying at the best of times. The first question today is, what is the best possible outcome for Diddy? And I'm assuming this means, other than saying, sir, you are completely innocent, you may walk.
I don't see a not guilty. I just don't. I could be wrong. Of course, I can always, there's always a chance. To me, I believe the best possible outcome is he cooperates. And that time may have already passed. I believe that if he would cooperate against other individuals, he would get what's called a 5K. A 5K is basically a reduction in potential sentence. If he could talk the government into dismissing some of the charges against him, I believe 0 to 20 years is his best possibility, his best chance. But that comes from cooperation, the government believing your cooperation is helpful, your cooperation taking down potentially a bigger fish than you, if you will. He could cooperate against some lower people and just get a little time cut off. But he'd have to do something exorbitant to cut time.
We've got this one from Emma.
Hi, Sean. Can you tell us when potentially well-known people's names might come out in the P. Diddy case?
I think the enterprise letters when you're going to start hearing other names. I don't think the names are going to be as interesting as people think. I think they're going to be inner circle names. I don't think it's going to be these great, interesting names that people are expecting to hear, but that, I could be wrong.
Another one that was really good that came from TikTok is, will they issue a superseding indictment before the enterprise letter, or can they?
Great question. Can they? Yes. And I'm being made to look wrong. I just believe that superseding indictment is coming. If it's coming, it's going to be before March. At that point in time, if they try to supersede this in case, I got to remember to in February, March, April. If they try to do it in like April, the judge is going to be like, no, we're not. He's not going to say, no, they can't do it. He's going to say, we're not going to trial in May if they supersede that quick, something of that nature. But yeah, I believe they're right. I still think the superseding is coming, but if it does come, it would come before the enterprise letter.
We've got a listener question for you as well that came through as a text on the WhatsApp. It says, hi, Diddy on Trial team, great podcast. I have a question. I'm reading that individuals who have close ties to the parties are starting to leave the US. What limits do US courts have if a named individual does leave the country with the so-called Diddy list to include individuals who do have the ability to relocate anywhere in the world? What risk does this have for the trials?
Great question, but remember, these individuals aren't charged with anything. So there's not bond conditions that would say that you can't leave, and that happens all the time. If you are not formally charged, the government has no control to tell you what you can and what you can't do. So if you think you might be a witness and take off, you're welcome to do that. Could it possibly hurt his case? Absolutely. But yeah, you can't stop somebody from leaving and saying, I'm going on vacation and I'm not coming back. You can put a subpoena in their hand. You can subpoena them for court, but that's the interesting part. You can't subpoena somebody outside the United States.
So if somebody, when this first, when the indictment was issued, they went, I'm getting out of here, and they left immediately, and they could be a key witness, and they went to, I don't know, Switzerland, you're not getting them back.
There's a difference between a witness and somebody being accused. I've seen judges say to them, it is not my fault you have lost your witness. It is your job to prove your case. Stop complaining. You should have had this ready beforehand. Now, if the person is a potential co-defendant, that's where the judge says, FBI, Secret Service, U.S. Marshals, go find them and go get them and bring them back. And that's where we start talking about non-extradition countries and things of that nature, and then it's hard to get those people. So there's a difference between a witness and a defendant. If you're a witness, you can go anywhere you want. The government cannot stop your movement. You can go where you need to go.
Sean, thanks so much for stopping by. We'll see you soon.
Thank you so much for having me. I very much appreciate y'all.
But if you have a question that you want us to unpack on the podcast, send them to us on WhatsApp at +44 330 123 551. That's +44 330 123 551. That's it from Diddy on Trial today. I'm Anushka Matanda-Doughty, and you've been listening on the BBC World Service. Make sure you subscribe to the World Service YouTube channel so you never miss a thing.